Good morning, everybody. Good morning. Hello. Hello, good morning. Welcome. Welcome, welcome. We had some developments that happened last night. And for some reason, I just could not get things uploaded. Good morning. When I went to upload these onto my Tube of You channel, they did not come through the way I had hoped, so I thought I would go through one more time here and include the additions that were made yesterday, and so that I would be able to kind of upload this for anyone who is interested. So I had been going through the Constitution last night on a live for anyone who joined me, and these informations kind of came down while I was going through that, so I did go through and try to explain, but I wanted to have a kind of a live just going through the additions here. I won't take too much time today to do that this morning, but then that way I will be able to kind of upload this onto my Tube of You channel for anyone who is interested. So we did have some last minute additions that were added in yesterday, and I just think it's can be helpful to kind of go through this information here again. So good morning, everyone. Good morning. Good morning. I'm working on trying to make my lives go quicker here. Yes, it is. It's absolutely riveting, I believe. It truly is. So, yes, we had some additions made in court yesterday on the protective order, and late in the evening, I wanted to go through just what has happened. I'm just going to break it down real quick, yes. Oh, thank you very much. Yeah, I won't be spending too much time on this. I just wanted to make sure that we had kind of a an overview here of what happened. So, were Republicans trying to frame this as freedom of speech indictment? I think it's, I think a lot of discussion is on, if you can say whatever you want, why would you be charged with that? But that's not really how the First Amendment works. But I think a lot of people feel that way, that it does work that way. So I think this is a really amazing learning moment in life. So for us to kind of figure out how that First Amendment works. Yeah, it seems to be taking a lot. So I'm going to just run through everything today real quick and easy for anyone who's interested, just because this information came in last night, and we kind of had some new information. So let's get started here. This is a copy of the docket that's going on right now in DC. So this is public information. Anyone can find this online, and you can go through. I've highlighted the defendant's motions, the court's orders, and then anything in green is the government. So, and then the order that came through. So, I'm just going to take a walk through these documents and just explain what they are. I'm not going to take too much time today doing that, but I had so many people asking these questions about what a protective order was. So let me just dive right in. I think we'll be okay for moderators this morning. Oh, thank you very much. Yes, I've got. Thank you. Yes. So I'm not going to take too much time. Yes, I know. I'm a talker. It's true. Let's try to dive right in. I'm trying to make a kind of clean live here that I can put up on my Tube of You channel for anyone who's interested. So yesterday we kind of had a few kind of sidebars. So, all right, here's what happened. here's what happened. On Friday, the government filed a motion for a protective order. And they filed this motion because, they're trying to be very careful about discovery. And one of the big discussions is they want to give all of this evidence over to the defendant, as is his right, absolute right. But they want to make sure that the evidence, the sensitive parts of the evidence, aren't made public. So there was a tweet, or not a tweet, but a social media post that had come out from the defendant. And after that had been posted, the government put together this motion for a protective order. So after they filed this protective order, they had also put in an order that had set out limitations on what kind of information can be given to the public. And this was a proposed order here for protection. So I'll take you through the motion. I'll take you through the proposed order. Now, what happened after this order was set was the court came in and said, all right, we've got a motion and a proposed order from the government. And so we need a response to that, and we need a response by the defendant by Monday. So, let us know what you think about this proposed order. Let's just get this taken care of. So this request that it be done by Monday was unacceptable to the defendant. So he filed a 25-page or 24-page motion to say, hey, we want more time to respond to your protective order proposal and all of that. So we need more than just a couple of days. It was filed late Friday. So yesterday they filed this motion to revise the schedule. And also they too filed a proposed order, and this was yesterday. So they put in this proposal. The government then filed another response. So to their motion for an extension of time. The government then said, hey, you've had time. We're trying to get discovery to you. So let's stay on target here. So after the government filed a motion, the court came back in, and this again was just last night, just a few hours ago. The government filed their response, and the court denied the defendant's motion for more time. So the original time that was set for Monday that the defendant has to respond is firm. So that's a firm date and time. So he needs to respond by Monday. And that order was entered last night. So last night she set out and said, look, we need to have a response. So that's the current status of the situation. Now, when the defendant filed his motion asking for more time, he had included in his motion that, he had stuff going on in Florida. Everything was filed on a Friday night, and that it was unacceptable that his response would need to be so quick. He didn't have time to prepare. So he put in and did, his support of his motion, and that was not persuasive to the court. So what I wanted to do this morning, and again, just real quick, I'm really consciously working on trying to make these lives just a bit shorter, just getting to the point, and explaining things just simple, and so everyone knows what's going on. But I want to take everybody through what each of these pieces are. They're very short. They're all very short, and letting everyone know kind of what the status was. Again, the final decision just came in last night. So it was kind of a pretty quick turnaround. So let's go through. Oh, you're welcome. You're welcome. Hopefully this is helpful for people. If this isn't something that's interesting, please feel free to scroll by. That won't hurt my feelings at all. I'm just trying to kind of explain what happened. Again, in having motions and orders done on a Saturday, a Friday, and a Saturday, it's not particularly necessarily unusual, but in this case, for things to be moving so quickly, I think everybody's got to kind of stay on top of it. So Let's go through this government's motion for a protective order and see why they filed it, see what it says, and then we will also spend just a little bit of time also on the defendant's motion and see, who's got the better argument and go through that. So, all right, here we go. We've got the government's motion for a protective order. The government stands ready immediately upon the court's entry of a protective order in this case to produce a substantial amount of discovery to the defendant. Discovery that defense counsel stated in the initial appearance yesterday that he needed in order to abide by the court's order to propose the trial date and estimate the length of the defense case. To allow the government to begin producing that discovery, much of which includes sensitive and confidential information, the government respectfully moves the court for entry of the attached proposed protective order governing the disclosure of discovery by the parties in the above captioned case. The court can and should enter it immediately to allow the government to produce discovery because the defendant can seek at any time to modify the order that he objects to. So they're saying, hey, we want to give you all of this discovery, but we need some protections put in place. So background: on August 1st, federal grand jury in District of Columbia returned an indictment charging the defendant with a violation of U.S. Code Section 371, 1512K, 1512C2, and 241. On August 2nd, the government sent a proposed protective order to counsel for the defendant. Defense counsel substantively responded on August 4th, which was today when they filed this, with a different proposed protective order that did not, in the government's estimation, protect numerous categories of sensitive materials, including grand jury materials and sealed search warrant affidavits. That same day, in an attempt to reach a compromise, the government drafted a new proposed protective order modeled on the one entered by Judge Carl A. Nichols in a recent criminal case and provided it to defense counsel, noting that the government intended to file a proposed protective order today. In response, defense counsel asked the government to note in this motion that they did not have adequate time to confer. So here's the government's argument then, saying, hey, we need a protective order. The government seeks to provide the defendant with discovery as soon as possible. And this is a huge issue because of this question of speedy trial and moving along with setting everything from the court's orders. So the defendant is saying, we don't have time. So the government's going into like, hey, here's some discovery we want to give you, including certain discovery to which the defendant is not entitled at this stage in the proceedings. The attached order would allow the government to do so while also protecting a large amount of sensitive and confidential material contained within the first production that the government has prepared. Now, production just means production of discovery, so that's just another legal term, and will send as soon as the court issues an order. Such materials include, but are not limited to, materials containing personally identifying information as identified in Federal Rule of Criminal Procedure 49.1. So I'll take a moment to pause here and just show you. These are the Federal Rules of Criminal Procedure that they're referring to here, and the rule that they're talking about is 49.1. And so if we flip through here, we can go to Rule 49.1 here. Rule 49.1, privacy protections for filings made with a court. So this is the rule that goes in and says, hey, we need to have some redactions. We need to have some protections for certain sensitive court documents that need to be come in, including for protective orders, anything that's been redacted, under seal, and so on. So this is the rule that they're referring to, Criminal Procedure 49.1. Rule 6, materials, including subpoena returns, witness testimony, and related exhibits presented to the grand jury, materials obtained through sealed search warrants and 2703D orders. Sealed orders obtained by the government's filter team related to this case, recording transcripts, interview reports, and related exhibits of witness interviews and sensitive materials obtained from other government entities. The court may, for good cause, enter a protective order governing or restricting discovery of inspection, which is what this rule says. Also citing case law here, a trial court can and should, where appropriate, place the defendant and his counsel under enforceable orders against unwarranted disclosure of the materials which they may be entitled to inspect. And then they're quoting the Alderman case, Courts regularly do so to expedite the flow of discovery in cases involving large amounts of sensitive information. When seeking a protective order, the government must establish good cause. Here, good cause exists because issuance of the government's proposed order would expedite the flow of discovery in this case, give the defendant prompt access to a large portion of the discovery he ultimately will receive, and protect the highly sensitive categories of the material described above. The government's proposed order is consistent with other such orders commonly used in the district and is not overly restrictive. It allows the defendant prompt and effective use of discovery materials in connection with his defense, including by showing discovery materials to witnesses who also agree to abide by the order's terms. All the proposed order seeks is to prevent the improper dissemination or use of discovery materials, including to the public. Such a restriction is particularly important in this case because the defendant had previously issued public statements on social media regarding witnesses, judges, attorneys, and others associated with legal matters pending against him. And in recent days, regarding this case, the defendant has issued multiple posts, either specifically or by implication, including the following, which the defendant posted just hours ago. Now, I believe that it was this post that really prompted the government to go forward with this protective order. If you go after me, I'm coming after you. If the defendant were to begin issuing public posts using details or, for example, grand jury transcripts obtained in discovery here, it could have a harmful, chilling effect on a witness or adversely affect the fair administration of justice in this case. And then they're citing case law here. The outcome of a criminal trial is to be decided by impartial jurors who know as little as possible about the case, based on material admitted into evidence before them in a court proceeding. Extrajudicial comments on or discussion of evidence which might never be admitted at trial obviously threatens to undermine this basic tenet. Finally, and importantly, the government's proposed protective order provides that either party can seek to modify that order at any time, meaning that the defendant is in a better position if he receives discovery under the proposed order's conditions rather than receiving no discovery while this motion is pending. If the court issues the government's proposed protective order forthwith without awaiting a responsive brief, the defendant will be free to move to review the discovery that the government will promptly produce and can seek any modifications of the order that he determines appropriate based on that review. And once in possession of the government's detailed, organized discovery inventory, the defendant will be in a better position to assess and justify whether to seek a modification to the protective order at all. So the government is really asking the court, like, hey, we've got an order, just sign it and we'll give discovery order. We'll give a discovery. What we find is that the court's like, well, hold on a minute, government. Great, thank you for your motion, but I'm a court. I'm going to kind of take care of business. So that's the government's motion. And now we've got the proposed government order. I'm not going to go through this word for word, but I will just hit the highlights here on this order. This is a proposed order by the government, and they're setting out that any of the information that's already possessed in public can remain public, what kind of materials they're talking about, and they're saying we will label all the materials in a certain way. And if we label something sensitive, then that cannot be disclosed. And so they're saying we will make sure to include the title, sensitive materials on anything that needs to be private. And then this proposed order goes on to say, what's the scope of the order? It means we can do modifications. There's no waiver if we forgot to put sensitive on the piece of discovery that we're sharing. No ruling on discoverability or admissibility. So this, again, is just purely a protective order. And any challenges to specific documents are allowed. So this is that proposed order by the defendant. That's it. Then we've got the response. This came down yesterday. This is the response from the defendant, a motion to revise the briefing schedule and set oral arguments regarding government's motion for a protective order. Now, this is actually a very short. This is just 2 pages with a couple of exhibits. So because it's only about 4 paragraphs, I will go ahead and go through this because I think it's important. We read through the government's motion. Let's read through defendant's motion here. At approximately 6 p.m. on Friday evening, the government emailed defense counsel its proposed protective order on document 10.1, which we just went through. and Exhibit A correspondence. So they included a set of emails that they received. The government entertained no discussion regarding the content or scope of the proposed order, but instead demanded an immediate take it or leave it response. Hours later, the government filed its motion, document 10, requesting the court to adopt the proposed order without awaiting defendant's responsive briefing. And that's true. That is correct. They said, hey, let's just get this done. Contrary to LCRR 47, a bedrock due process principle. Here's the case here. Ex parte proceedings, particularly in criminal cases, are contrary to the most basic concepts of American justice and should not be permitted except possibly in extraordinary cases involving national security. Now, this case that they're citing here, this is a good point, but we do have ex parte things that do happen due to necessity, and we do have kind of a unique case. So this isn't necessarily that unusual, but it's a good point. This morning, the court entered a minute order. And again, I would draw your attention, if you're wondering what a minute order means, they're referring to this order here, okay? So if you pull the docket up, you will see minute order. So this is what he's referring to. Directing defendant to respond by August 7th at 5 p.m. To ensure counsel has adequate time to prepare a fulsome response, defendant respectfully requests the court briefly extend this schedule by 3 days to permit the defendant's response by August 10th. This is substantially less time than provided for by the local rule 47, generally allowing 14 days to respond to motions, and will enable defendant to fully assess the proposed order and advise the court of the applicable law. And then we'll turn the page. Again, we've only got 2 paragraphs here for the defendant's motion. The rest of this 24-page motion are exhibits supporting their position. Additionally, a brief extension would provide time for the parties to meaningfully confer and potentially resolve this dispute without court intervention. Without doubt, discovery in this case will be extensive and likely present numerous complex issues. For that reason, it's essential to structure the parties' discussion in a methodical and ideally cooperative manner. Friday evening ultimatums given by the government before even calling defense counsel are wholly unproductive and undermine the potential for party-driven resolutions. Requiring a Monday response to a Friday evening motion, likewise, forecloses the possibility of agreement and would encourage such improper tactics by the government in the future. And we've got an endnote here. Let's pop down, and it says, indeed, the government's lack of conferral represents a concerning pattern. Just 3 weeks ago in a U.S. v. Trump, and this is the Florida case, the government made a similar demand for a Friday night response to a proposed protective order, followed by a near immediate motion for relief. The government admonished this recalcitrant approach and denied the government's motion without prejudice for lack of meaningful conferral. That the government would use the same tactics so soon after is plainly improper. So he's pulling in the Florida case here to support the fact that they've done the same thing before. It seems he's very frustrated with this idea that something was filed Friday and then a response is needed on Monday. A defendant is prepared to confer in good faith regarding an appropriate protective order and hopes the government will accept his invitation to do so. In the meantime, an additional 3 days to brief this important issue is reasonable, consistent with local rules, and serves the interests of justice. No party would be prejudiced by the requested relief, as this case is at its very early stages, and no matters are currently pending that require the immediate resolution of this motion. Finally, should the parties be unable to agree on an appropriate protective order, defendant believes a hearing would be beneficial to the court's determination of the motion, which involves significant legal, factual, and procedural issues that can be most effectively presented and resolved in an oral setting. As such, defendant respectfully requests the court set a hearing on a motion for the first available date following the conclusion of briefing. And then that takes us down. As explained above, as a general matter, we think it important to confer prior to the filing of any motion. However, given the circumstances presented here, where a defendant has been ordered On a weekend to respond by Monday afternoon, we determined it necessary to submit our proposed briefing schedule as soon as possible to obtain clarity regarding defendants' obligations. Consequently, we have not conferred with the government regarding this application. So this again is the motion in response filed by the defendant, and the attorney is signed here. Now, I will just show you here what he included as exhibits. I'm not going to go through all of the language, but we have Exhibit A that he submitted, which is a copy of the emails going back and forth talking about this protective order. On Friday, we've got 6:39 p.m., 2:45 p.m., 2:39 p.m. It seems he's really frustrated with this idea of all of this kind of going down on a Friday evening and then with a Monday response. More emails here at 1:09 p.m. On August 2nd here. He's showing that the same thing happened in the Florida case as well. So that's what Exhibit A is about. Now we've got Exhibit B that was listed, and Exhibit B is the criminal docket for his case in Florida. A very detailed listing of the criminal docket, and it's just page after page of the counts that are pending in Florida, all of the lawyers that are included, all of the docket. This is all public information. Again, this is the Florida case, so this is his Exhibit B. Again, the full docket with all of the different documents and everything that's been filed. This was included to kind of support this idea that he's got this other case in Florida that the government's also involved in, and explaining, that this is showing a pattern of behavior, I think is his argument here. Now, I think it's good to know, we do have, just as a side note, someone had pointed this out in the live last night, on August 1st, there was a paperless order here where the arraignment on the superseding indictment is set for August 10th at 10 a.m. So just as a quick side note, I wanted to put that out there. I did go through the superseding indictment already, but that arraignment is set for the 10th, which is also the date the court requested he respond to the government's motion for a protective order. Now, this is the defendant's proposed order that he submitted, where he's saying we would like an extended period of time in order to continue to review the protective order proposed by the government. We would like a few more days. And so this order reflects that. That then takes us to the final piece, which is the government's response to his motion for an extension of time. So I think this is very interesting. It's just a couple of paragraphs, and it really kind of pulls everything together. So this was filed again by the government yesterday in response to the defendant's request of extra days to review the protective order and motion. The government wants to provide discovery to the defendant. That's an important sentence here. They're saying, hey, we're trying to help him out. But again, we do have proper procedures that need to be followed. By his motion, the defendant seeks to delay that process. The defendant's motion should be denied. 3 days ago, on August 2nd, the government proposed to defense counsel a protective order that largely tracked one entered in the defendant's other pending federal criminal case in the Southern District of Florida. In emails not appended to the defendant's extension motion, the government, so they're saying there's more emails that weren't included because the defendant had put Exhibit A in, but they're saying there were more emails. The government followed up on the evening of August 3rd and early afternoon of August 4th. Thereafter, defense counsel finally responded by sending an entirely different protective order. We have a little bit of some passive aggression in the government's response and some actual outright aggression, which we'll see in a few minutes here. Since the defendant's proposal was inadequate, the defendant proposed another alternative. This one, modeled after a protective order entered in a case by Judge Carl J. Nichols, recently tried by one of the defendant's attorneys present at his arraignment. Defense counsel declined to substantively confer on that proposal on a Friday evening, after which the government moved separately for an entry of the order. The court ordered that the defendant respond by Monday with a red line of government's proposal. Rather than spend time complying with the court's order, the defendant drafted a filing as to why he did not have time to review and consider the 5-page proposed protective order. So this is the moment here where the government's being a bit snarky. They're saying, hey, why did you put together a 24-page motion in response, but not review the 5-page protective order? Can everybody hear me okay? I think I just got someone had said there was no audio. Can you hear okay? We're almost done here. Everything working okay? Okay, good. Thank you. Thank you. Thank you. Thank you so much. Yep, we're almost done here. This is the very quick overview, quick but thorough explanation here. All right, so the last paragraph here, the defendant's extension motion proposes unnecessary delay to normal order. The defendant suggests that delay will enable the defendant to fully assess the proposed order and advise the court of applicable law. Nothing prevents the defense counsel from doing just that on a schedule already ordered by the court. To the extent defense counsel wants to confer further, government counsel is available at any time, evenings, weekends, or holidays. So again, we've got a little bit of snark here from the, from the government. They're saying, look, we're always available. And if the court enters the proposed protective order and the defendant later is dissatisfied, the defendant can seek to modify the order at any time. The government stands ready to press send on a discovery production. The defendant is standing in the way. Ouch. That's pretty harsh. The defendant should deny the motion. The court should deny the motion. So that's pretty harsh. That's pretty harsh wording from the government here. So, all right, that is the response, which takes us again to the final piece here that came down last night, where we have the response here by the government. And here's the order. It says, as to Donald Trump, defendant's 11 motion for extension of time is hereby denied. Defendant may continue to confer with the government regarding the proposed protective order before or after the August 7th, 5 p.m. deadline for his response. The court will determine whether to schedule a hearing to discuss the proposed protective order after reviewing defendant's response, and if included, his revised proposed protection order with modifications in red line. So this is very typical. The court is saying, hey, both sides, both of you, you're going to need to settle down. We've got an order that we need to do things in, and you need to follow that order. So the court is saying the government's not going to be able to rush through a protective order, but we're also not going to extend time for the defendant. So the court said, hey, August 7th, let's get it done. We'll review. If we need a hearing, we'll have it. After we review the proper procedures, then we'll go forward and make that determination. Yes, exactly. We're not rushing. We're not adding extensions. We're getting it done. So what's important here is that we are following procedure, and I believe she's spot on as well. She's pushing both sides back. She's kind of holding them back and saying, hey, look, I get it. We need to follow the rules here, but we are going to be very, very careful about how we do it. But she's also, saying we're also not going to wait a long time. You got this protective order proposal. It's 5 pages. It's take a look at it, go through it, and that should be an adequate amount of time to come back on Monday with your response to it. Yes. Yep. So that all just happened within a very short period of time yesterday. So this was just within a couple of hours last night that all of this went down. Where can I find all of these documents? So you will go online to whatever search engine you prefer. You will put in US v. Trump DC court documents, and it'll pull up a few different websites. You can take a look and see what's available and look through it until you find what we call the docket. And what you're looking for when you're looking at the docket is you're looking for the file here, the file number, along with a list of what's been filed here, the dates that's been filed. And then you'll be able to make sure that you have the actual docket set out in front of you so you know what you're looking at. Would I be interested in coming on your show? Avoid cast clips. Maybe. Leave a comment on one of my videos so I can get back to you directly. But we'll have to see. I really am just talking about the law. So I'm really, that's, if that's what you're interested in, you can talk. Please keep doing this. It's so helpful. Oh, good. I'm glad. Yes. And again, this morning, I'm trying to just really keep it, short and sweet. I'm really trying to kind of, whittle down what I'm talking about. So I'm just getting right to the point. And then I will kind of upload these onto my Tube of You channel for anyone who wants to review it. So, okay, great. Sure. Excellent, because you aren't either way. Yes, I'm not. I'm really not. Oh, thank you. Yes, I'm not. I'm just explaining here what's in the document. So, yes, absolutely. I think it should be free and easy to access. And yeah, I'm certainly not doing any of this for any kind of monetary gain whatsoever. I'm doing this completely just to educate, explain, and help people understand what's going on. I think that's important. Mm-hmm. Yep. Well, and he may be found innocent. Absolutely. We really don't know. We don't know. We don't have proof beyond a reasonable doubt. We only have probable cause for the indictment. We need to have a jury in order to determine that. So, yes. Oh, you're welcome. Yes. I think there's plenty of places to go if you want a particular political view on it, which is absolutely fine. But that's not here. That's just too much for me. I don't think that's helpful for people. So I'm just here. I'm just spitting facts. But again, this all did just come down yesterday. So it is kind of frustrating to try to figure out what's going on. And lots of people are talking about it and tossing out words like protective order and all of these things. And it's not really explained. So I think this is pretty, just, going through it and looking at the four corners of the documents and the law, I think can be helpful. So, and then each of you can go and decide what you think and make your decisions based off of, facts and law. So hopefully it's helpful for people. So, oh, thank you. You're welcome. Yes. Yep. I'm just here for facts, just to kind of explain things. Yep. I have no preference one way or the other. When I'm on TikTok, of course, in my private life, I've got my own view on things, but I think that is just not helpful for people. My particular view on things is really not politically is not relevant. I think it's just good to go through just the facts. So. Oh, you're welcome. Yeah, I mean, you can. I think it's within your purview to decide what you think is right, what you think is, if it's being handled correctly or not. That's up to you. Go for it. Make that assessment. But I think it's important to have all of the facts, all the information, and once you gather all of that, then you can go forward with however it is you choose to go. And that's completely fine. There's nothing wrong with that. How it should be. Yes, I think a lot of people are wondering if we could televise the trial. And again, the number one concern, we need to have due process. We need to have a fair trial. That's the absolute number one most important thing, is that we have a fair trial. And if you've got cameras in the room or media lingering around, I think it's important to have transparency, but I don't think transparency is more important than a fair trial. I think that is the absolute number one goal. So we really just have to make sure that whatever happens, that we're doing it in a way that does not inhibit or keep away that element of due process. That's so important. Yes, as fair as we possibly can. Nothing is ever perfect, but it's important. So, yes. You're welcome. Oh, you're welcome. Hopefully this was, again, helpful. I will be putting this up on my Two of You channel to, again, I did do a couple of lives yesterday, but was struggling to actually get them up on my Tube of You channel. I had a few technical problems, so that's kind of another reason why I wanted to pop on this morning and kind of go through it one more time so that I could move it over to that format for anyone who's interested. I'm not sure anyone's afraid of this man other than probably the people that are being included in this protective order, and other people that may have some kind of safety concerns. But yep. Well, yeah, maybe, yeah. I mean, I can see both sides on that. I think everybody kind of has their, yes, my tip of you have to be, respectful of the TikTok guidelines. So you're not supposed to really promote or add in any other kind of things like that. So I just kind of tiptoe around the guidelines very carefully. Yes, I think knowledge is powerful. I think it absolutely is. And, if you go and you look this information up and you learn about it and you come back with an educated perspective on it after gathering the information, whichever perspective you have, but you're using the evidence to draw those conclusions, I think that's fantastic. I think that's great. Absolutely. I think that's what is important. So, absolutely, absolutely. It really is. It really is. And again, I certainly can't tell anyone which way to go on that. It's completely up to you. I can just offer the source for facts here, for facts in the law, and explain it, which I don't see. I can't seem to find. I see there are some other people trying to kind of do straight facts, but it's really doesn't seem to be the headlining any of the publicity. So I think it's, I'm just I've got this little tiny corner here. I'm just trying to kind of help out where I can. So, yeah, absolutely. Make that educated inference. Absolutely. Sure. Yep. Go for it. Whichever way you choose to go. So, Crystal, I did just finish reading. I'm trying to kind of cut my lives a little bit shorter. They've been going just a little bit too long. Good morning. Yes, good morning. But I'm just kind of doing a quick Q&A here, just for a couple more minutes, and then I'll be just directly uploading this to my Tube of You channel for anyone who would like to kind of go through it. So, for anyone who's interested in that. Yes, you're welcome, Deborah. Yes, thanks for joining me. I appreciate that. Yes, and notifications are good. I'm trying to schedule when I come on. I do have my regular content that I go through, where I go through different U.S. Supreme Court cases and the Constitution and so on, and I always put a notice up for those. But sometimes with these motions and these things happening in these huge trials, they just kind of happen, and so I just hop on when I have a minute. When I'm able to, based off of my own schedule as well. So sometimes it is last minute. I think the best thing is to put those notifications on so you can have the most up to date. The other thing I'm telling people to do is just kind of, if you come across something, just tag me on it. If someone's talking about certain documents or certain parts of the trial or the indictments or any of these kinds of things, and you're like, oh, I'm not sure that's right, feel free to tag me and I'll take a look at the video and kind of clarify things the best as I can. I'm happy to help with that in any way that I can. So just feel free to tag me on that. It's no problem. So see, one of your law degrees. Yes. Well, Steve, I've been on TikTok for a little while here and I've had a couple of problems. So I keep my privacy relatively condensed. So I am accredited law school. I do know attorneys in my area are familiar with me. So my Supreme Court here in my state is as well. So I do have a lot of people that can back me up on that, but I do choose to kind of keep some information private just for safety reasons. So, but yep. And I did just post today the Biden versus Nebraska case on student loans. So speaking of law degrees, my student loans are definitely part of that as well. So Yes, yes, I'm happy to share, but I do need to be careful. I think I'm just very um, I just know what can happen if that information is too much shared. So try to yes, yes, student loan forgiveness, very controversial, very controversial. So we will see what different roads we can go down. So, but very interesting. The Biden v. Nebraska case, very interesting. I can see both sides so very, very clearly. I think it's a great case to really look at both sides and say, I think I would have decided differently, or I think that was an excellent decision. I think that's a great case to see both sides of that. So, yes, absolutely. So, in the interest of again trying to make my lives be a bit more condensed and not as long, my Tube of You channel is the same as my name for TikTok here, and I will it will take a little bit for everything to process through. But I will be posting it as soon as possible. So it takes a couple of hours for these lives to process, and then it takes me a little while to just upload them. So, oh, thank you for the moderator shout out. Of course, yeah, come join me next time. Sometimes I really do need. I've got so many great moderators that come on. I'm so very thankful, but definitely the timing of it is, I hate to ask my moderators to come on so much, so I'm always thankful for volunteers. So thankful for that. So, but I will just take a few hours, of course, technically, for all of this stuff to kind of come together. But we'll have this up on my Tube of You channel for anyone who wants to go through it again. So, and I'm just explaining what these different documents are. When I've got any new documents coming down, in this case, the Florida case, those are the two primary criminal cases that I'm following at this point. And it just worked out that way because they're just amazing tools for learning because so many things are going on in these cases. So yes, and my Tube of You channel is the same as my name here on TikTok. So and go ahead and put those notifications on if you want to make sure that you catch. I just am not able at this time to predict when these things are coming down. I was actually on streaming last night when all of this happened. So I had to pause in my streaming, and one of the people had said, look, there's some more stuff out. And I'm like, oh my goodness. So it's just kind of how this process is working. So please feel free to click on those notifications and then check out my Tube of You channel if you are interested. So thank you again, everybody, for joining me this morning. Oh, thank you, Jim. I appreciate that. It was quite the live. So many great, wonderful questions. So I do not plan on going back on again today. So this is kind of my set for today. I will keep everyone up to date as best as I can. So feel free again to tag me if you've got any other questions or things that are going on. And I thank you all again so much for your time and interest in interesting questions. So take care, everyone. Have a great Sunday.